wanted a little more decorum and wanted us to try to narrow the gap a little bit, so.
Right.
That's just my take on it.
Mr. Chairman, if I may, I just should point out for the committee and the supervisors that when I was drafting this, I did go on to the Committee on Open Government website to see if they had any guidance. Really, the answer to that was no, but they do point the reader into a case law, and the case law standard is that certainly a board of supervisors, or any municipal board for that matter, can adopt reasonable regulations, governing public comments. And it even talks about the fact that public comment really isn't even required. We haven't followed that. We've always allowed public comment, and I didn't draft this with the intent that we would do anything other than allow our current arrangements to continue. But if you're going to adopt regulations or rules about your procedures on public comment, they have to be reasonable, they have to be fair, they have to be sort of content, point of view neutral, those kinds of things.
Right.
So that's what I tried to accomplish.
Section 2.1 is regarding public comment during discussion and public comment on proposed resolutions appearing on the agenda. I think from what the chairman is saying, maybe we should add relative to the resolution under consideration, just so that you can keep it on point at that point. There's another point. The second item is during the privilege of the floor, and so that I think could be on anything. But when we're discussing a resolution, you don't want to wander off on some other area.
No, and on our agenda now that we hand out, we have privilege of the floor to discuss resolutions. So I guess we need to, ask what specific resolution you're addressing to stay on point, because then you can get off into all sorts of making statements.
Right. Okay.
I agree.
Okay, so I think this is good, so maybe we could just distribute this to all the supervisors. Ron?
Yeah, I think that on presentations, I think how a presentation gets on the agenda needs to be spelled out. I think that probably an actual formal 15-minute presentation, it seems to me, would be by full discretion of the chair, as opposed to a public comment. In your section within the municipal association will be making a presentation. How does one find oneself? I mean, we've had different presentations over the years.
Usually they will address the clerk of the board. And
Right.
The clerk of the board usually will contact whoever the chairman of the board is and say, so-and-so wants to make a thing. And that's worked very well, as far as I'm concerned. Anybody who comes in ahead of time, just so we have an idea. And we try to limit it, because you have so much work you want to get done at that meeting. So I think it's worked pretty well, but I think maybe you want to add a sentence that, you need to contact the clerk of the board. And then the clerk of the board always communicates with me as chairman.
Right.
Or whoever the chairman is. That's the way you've always done it.
Yeah, it is.
Yeah.
Okay. Yes, Jim.
One problem that happens sometimes, I think, is that we have a meeting and people will speak, and there may not be a lot of people who want to speak, and so they go over the 3 minutes. And then another time, there's a lot of people, and the chairman will say only 3 minutes, and people will say, well, you allowed us to speak before. So I wonder if maybe this 3-minute thing should be at the discretion when the chairman wants to.
Mr. Chairman, if I may, I think I may have addressed that point. But in that, it says generally comments by speakers will be limited to 3 minutes. That's just because when I was drafting this, Supervisor, that's what I've heard before. And in my municipal experience, that's not uncommon for 3 minutes.
I don't
and then when I said there's an opportunity to request additional time as well in here, and it says, depending upon the length of the meeting or public hearing and the perceived or actual level of public interest in the subject matter, the chairperson may allow for additional comment by an individual who has previously provided comment during the same meeting or public hearing on the subject matter. In order to request an additional opportunity to provide comment, the individual must first be recognized by the chairperson. The individual will then approach the podium and state for the record the subject matter for which they desire to make additional public comment. In all instances, the chairperson shall have absolute discretion to allow or disallow the additional public comment. Any additional public comment must be relevant and material to the subject matter of the meeting or public hearing and shall not be repetitive or redundant of comment previously provided.
I don't have any argument with that. I'm just saying that maybe it should say that once the chairman announces the 3-minute rule is in effect or something to that, so that people know that we're under a slightly different rule rather than when it's slightly more give and take. You know, that way people can't say, well, you're arbitrarily, you know what I mean, where people are.
Well, we try to keep it to 3, and I try to time it, most generally, I mean, you know, somebody will go over.
Right, no, I'm just saying that sometimes when you're really sticking to the rule, it might be in terms of perception, people might, you say, well, all I'm going by is, like, Glens Falls County Council will allow people to speak, but sometimes the mayor will say, we're gonna have a 3-minute rule here, and everybody knows that it's not arbitrary, just because of
Right, we don't have a
practicality.
timer. We
Right,
have
no,
the
but I'm
8 timer.
saying.
But
I'm
at the
just saying
beginning of
maybe-
the meeting.
Huh?
At the beginning of the meeting.
At the
That's
beginning
fine.
of the
When we
meeting.
go into public comments, I try to say,
Right,
I
you
try
got
to
3
say it, sometimes we, you know,
Yeah.
okay.
That way they know they have
That's
3
good.
minutes.
3 minutes.
Well,
I mean, the
But
rules
they're your
are-
rules, so whatever you.
I'm just saying, at the beginning of this thing, you might say, once the chairman announces it, this is what will go up and down. I don't know, I'm just.
What I tried to do here was to make this subject matter specific to the public comments themselves, not how the chairperson is going to run the meeting. Not to say that I can't do that, but just so you know, when I was drafting this, I didn't have that in mind. I had in mind we know how we're running the meetings. If I'm a member of the public, I know what I can do.
Either way works for me.
I'm just saying, sometimes we're not consistent, and
Oh, no, you're right.
it just,
Absolutely. And
I
I
hope I'm
hate,
making myself clear, I don't know if I.
yeah, I hate to cut people off too, you know,
Right.
that's one of the things. When you're sitting up front, it's hard to cut somebody off, but sometimes you have to.
But sometimes practicality is
Yep.
not.
Well, the one other thing that I don't think is addressed in this is, you know, someone taking multiple opportunities to speak, where, you know, you give them 3 minutes, and then they sit down, somebody else speaks, and then they get up again, another 3 minutes,
Right.
and then another 3 minutes, another 3 minutes.
But don't you think Martin covered, I just saw that, in this section where he just read before, that the chairperson shall have the authority and discretion to adjust speaking time limits, but then if he's already previously provided the comment, I would think that he then does have the discretion to say, okay, you've spoken once, I'll let you speak a second time, but
Quote my colleague from the town of Queensbury with a lot of reference, you get one bite of the apple, is
Yeah.
what Dan used to say at his meetings, and, you know, I think that works. We know that.
We do get 2 bites now.
2 bites?
At Queensbury.
Okay, but you remember, John, that Dan used to always say,
Well, we got different. After everyone else has spoken
Yeah.
for 3 minutes, then you can come back.
for a second time.
Yes.
So you
Okay,
you like
try
the
to-
2-bite rule.
Yeah, okay.
I don't have a problem with the 2-bite rule either.
No, okay. we can work
Okay.
that out.
Okay, so we can't take any action on it, but I think if we just pass this out, we'll get a lot of feedback.
Good.
Okay, so item 4.2 is county attorney address the committee relative to 2 resolutions approved at the March 9th committee meeting, but not presented at the March 20th board meeting relative to support for amendment to the New York State Social Studies Learning Standard number 5 and supporting adoption of New York State law to amend the educational law in relation to Common Core standards. So I'd turn it over to the county attorney. And also, I should point out, I received a packet of information from Bob Schultz. Does everyone have a copy of that? Okay. And it's based on some Okay, another letter today. Okay, okay, so there's also a chart that came to, a letter with the chart, and as article speaks to Common Core's violation of the Fourth Amendment, which is, from the president of Educational Liberty Watch and co-founder of the Florida Stop Common Core Coalition. And then attached to the letter of March 30th is, I believe, a case decision from the state of Missouri. Okay, time point. Okay.
Thank you, Mr. Chairman. Following the last committee meeting, I did have an opportunity to closely examine both resolutions, one in relation to Common Core State Standards Initiative, the other in relation to Learning Standard number 5. I spoke to you about that review. I also spoke to Joan Sadie, and because these resolutions, you know, really kind of out of our purview, to be frank, but because these resolutions make some affirmative findings about New York State being in violation of the Constitution and various other provisions, I mean, I really didn't think that we were a court of law where we should be saying that, you know, New York State is in violation of this, or this standard was adopted in violation of the Constitution. I don't know whether that's the case, and I don't know that anybody here has an expertise to actually make that finding as far as the, you know, the County Board of Supervisors goes. But I do understand that these were before you, and I came up with the idea of saying, look, you know, we've heard the resolutions have been drafted, we had a presentation, but I thought it would make good sense to get input from the Board of Regents, the Department of Education, and also our school districts throughout Warren County. So after conferring with the chairperson, I took it upon myself to write a letter to the Board of Regents, write a letter to the State Education Department, write a letter to each and every one of the school superintendents of our school districts throughout Warren County. And I sent them copies of these resolutions and asked them for input. I suggested a 45-day period for them to get back to me. We're within that 45-day period. So I haven't received any comment back yet. I also, subsequently, I called, these two resolutions, as I understand it, were before the Washington County Board as well. I called Roger Wicks, the Washington County attorney, and the Board of Supervisors in Washington County declined to move forward on either resolution. So I've read the materials provided by Mr. Schultz, and I've read the statutes that he has cited. The case that he cites for the common, I guess in support of the Common Core Standards resolution, is a case from a lower court in the state of Missouri, a county court, circuit court in the state of Missouri, and as I understand the materials that have been presented, that it was a fairly recent decision, the March 10th publication that came out about that Mr. Schultz provided us with indicated that the State Attorney General in Missouri was planning to appeal that decision. So I guess I'm just hesitant to recommend to you that you use that as a basis to do anything. First of all, it's Missouri, it's not New York. I understand Mr. Schultz's arguments, that there's arguments by analogy, but I'm hesitant to recommend that you move forward based upon that. But first and foremost, I think if you're going to do anything here, I think we should see if we get any reaction back from State Ed, Board of Regents, and our school superintendents or boards of education. So that's my position.
Okay. Okay. Bob, do you want to make a presentation to the committee?
Yes, thank you.
Excuse me?
Good morning,
Okay.
and
yeah.
thank you again for your service. The chart that is attached to today's agenda,
Good.
we could just turn to that for a moment. I might say at the outset,
It's folded over and attached to the letter,
This is it?
today's letter. Yep. I think that's what you're referring to, right?
State ed law,
This is what you're referring to?
state ed
Yes.
law.
Okay.
The chart. The question here with respect to, the civic education resolution, with respect, Mr. Affadu, this is not a political question. It's a legal question, and the facts are few, but very irrefutable, as this chart shows. The education law, the law passed in 1941, is there, Section 801, 1 and 2, makes it very clear that all teachers of the state are to teach all children of the state in public and private schools from grade 8 on. Quote, the history, the meaning, the significance, and the effect of the provisions of our state and federal constitutions and the Declaration of Independence. It hasn't been happening. As I indicated, I'm a graduate of the public schools in 1957. My grandson, I wasn't taught. My grandson just graduated last year from Lake George. He wasn't taught. No one's been taught. The meaning of that statute, passed by the legislature, signed by the governor, is that by the time the children leave school, they are to know what's in the state constitution, how it got there, why it's there, the power of those provisions, as well as the U.S. Constitution. They're not being taught. So they can't make any connection properly between what government is doing at every level and what the constitutions prohibit them from doing, or that mandates that they do. In Section 802 of the state education law, by the way, the chart, the bolded language, is the language that we're encouraging be carried over and be added to the Social Studies Learning Standard number 5. So under 802, it makes it very clear, this is law. This isn't a political question. This is law. That the instruction, the children are to be instructed on the display and the care of the flag. And that such instruction shall include, as a minimum, the provisions of Section 170 through 177 of Title 36 of the U.S. Code. That's New York State law. And so there you have in the third box the current learning standard. Woefully inadequate. Mentions the United States Constitution, makes no reference to the New York State Constitution. I can tell you from my 36 years of experience of going around the state and other states, most people do not know there's a state constitution, much less what's in it. And yet it's that state constitution that governs the behavior of every single elected and appointed official in the state, far more so than does the U.S. Constitution, which hardly ever comes into play in the day-to-day administration of our states. And so there it is. And in the fourth box, that's the proposed language of the amendment. And all it does is carry over from the law, 801 and 802, that key language, making, in other words, instruction comply with the law. These learning standards are crucial. As you know, it's Board of Regents adopts learning standards in math and language arts and social studies, and all curriculum must teach to those learning standards. So we need an amendment, and all we're asking you to do is call upon the State Board of Regents to amend the learning standard, to bring it into compliance with the law, because it's not in compliance now. And those facts, Mr. Affadu, those are the facts. This is the law, this is the learning standard, current, and this is the proposed learning standard. And would this not be an improvement? Would this not help our schools to teach the history, the meaning, the significance of every provision of our state and federal constitution over a 5-year period. The other resolution deals with Common Core, and it would have you calling upon the state legislature to adopt a statute that brings New York into compliance with the U.S. Constitution. Those two articles, the 10th and 4th article, and the two amendments, the 10th and 4th, and Article 1 and Article 4 of the U.S. Constitution. And as I had said at the March meeting, I was in the process of obtaining the decision from the Missouri court and would get that to you, but you made your report prior to your receipt of the Missouri papers, court basis. And sure, it's a lower court decision, but you have attached to your papers now the complaint, extraordinarily well done complaint in terms of its detail, and you also have in your packet the restraining order and then the final judgment. There is no question but that the assessment consortium that New York State is participating in violates the Compact Clause. It's an interstate compact that was not approved by the U.S. Congress as the Constitution requires. Sure, it's Missouri, but the allegations in that complaint, as I, in my March 30th letter, I identified the paragraphs. Those paragraphs, the allegations that are factual and that apply without reference to any state. And there were some 40 of those. So the facts of the Missouri case are the facts of, that apply in every state. And yes, they joined the assessment consortium known as SBAC, Smarter Balanced Assessment Consortium, whereas New York has joined the other assessment consortium, the PARC consortium. But the complaint goes into considerable detail and speaks to both assessment consortiums as being in violation of the Compact Clause. So you have additional information regarding the law in support of the resolution, asking the State Board of Regents, the Education Commissioner, regional school districts, to weigh in on the civic education resolution is, I would argue, is totally unnecessary. You have the facts in front of you. It's not a political question where you want everybody to comment. It seems we have the capability of looking at the law and seeing if Common Core and civic education is outside the law.
Mr. Chairman, I just so you know, for the record, I never looked at this as a political issue. I looked at this as a legal issue.
Mhm.
And I'm not quite sure I understand why the State Department of Education, the Board of Regents, and the local superintendents of schools or boards of education can't comment on this from their perspective of the law on the civics standard. I just think, anytime you're going to entertain a resolution that says, and this is Mr. Schultz's language, the current New York State Learning Standard for Civic Citizenship Government fails to comply with sections 801 and 802. Well, he says that. We don't know that. He says it's irrefutable. We don't know that. That's his position. The State Education Department, the Board of Regents, may take a completely different position on that. And I think we, as a Board of Supervisors, should be soliciting their comments, if we're gonna make a statement like that, that we say it fails to comply, that we say it's in violation of law, who are we to say that?
Isn't
Without at least having some input from them.
These are the people who are responsible for the violation. Isn't it a better course of action, a more productive course of action, to pass a resolution calling upon them to amend the Learning Standard Number 5, Civics, Citizenship, and Government, to read as we propose, and let them comment, you know, and advise why they would not amend. But
I've stated-
they're
I've
responsible.
stated
No
my-
unit of government likes opposition from any quarter. I mean, they're responsible for this. And so why not pass the resolution? And if it's constitutional or if it's legal what they're doing now, they'll say so.
Mr. Chairman, I've stated my position, but just to, I think Washington County smartly declined to take action on both of these resolutions. It's my recommendation that you take no action on these resolutions until we hear back, if we hear back at all, from the individuals and entities that I wrote to.
Okay. I mean, the reality of our situation today is we don't have a quorum anyways, but, so I think what I would suggest at this point is that we make Mr. Schultz's submissions available to every member of the Board of Supervisors and discuss it further. You can discuss it further at the next full board meeting or at a committee meeting.
Yeah, I'm fine with that. I mean,
Yeah.
you know, there's been a lot said about Common Core, but, you know, I have a tendency to agree with Martin. Let's just get input. If we don't get input, then we can make our own decision without input. I mean,
Well, in any event, I appreciate the opportunity.
Yeah.
I was not given that opportunity in Washington County.
Oh, is that right?
I was not aware of what path they were going to take or in
Yeah.
fact took. So, but I appreciate you.
Okay, thank you, Jim?
Yeah, Mr. Schultz, are you saying that, Declaration of Independence in the U.S. Constitution isn't taught?
They mention it. Mr. Sproul was here at the last meeting, and I believe it's true that he's taught social studies to the
I
8th
did
grade.
too.
Okay.
Mm-hmm.
And so they'll mention of course, they'll mention the Declaration of Independence. They'll mention, of course, the U.S. Constitution. I don't know that they mention the state constitution.
Well,
But what's important, forgive me, but what's important is that the law requires that what be taught over that 5-year period is the history. This is the language of the law. History, meaning, significance, and effect of every provision of these documents. Remember, no word finds its way in or out of the state constitution except by the vote of the people. It's the people structuring and regulating the government. Okay, extraordinarily important document.
Right,
And those provisions are not being taught.
well, they are.
Okay, so you have
The only.
war powers provisions of the U.S. Constitution. You have money provisions of the U.S. Constitution. In the state constitution, you have debt provisions. You have that limit. You have provisions that say no public money or credit can be given or loaned to or in aid of any private undertaking. And yet it's routinely violated. We're a home rule state. That makes it very clear, the Constitution makes it very clear, the state legislature is not to pass any act which affects the property affairs or government of, say, 1 or 2 or more counties, but not all counties at the same. But that's being violated. I can speak to these issues because there are dozens of complaints. I've won many, I've argued at the Court of Appeals, but I can speak to this, you know.
Well, what I was gonna say is, the Declaration of Independence is taught, the U.S. Constitution is taught, case law is taught, the New York State Constitution is just mentioned, like you said, that isn't, it depends on the teacher, I'm sure. But where I think we're woefully, doing a poor job is with local politics, and, it's in that area that
Well, I think his argument is it's not in the standards, it's not in the, that it's not in the learning standards, but
Well,
even though it may be taught.
you can't teach U.S. history without teaching the Constitution.
Right.
I mean, a lot of things are just mentioned, like, might say the American Revolution, but, you know, you can't just stand in front of class and say American Revolution, you gotta keep it the details of it.
So, if I might, I don't, this is not a forum for a debate, but I would like to just, briefly have the record left, at this point without saying this. It's my perception, doing this kind of work for 36 years, it's my perception that, we have a culture. Children are being raised in this culture, and they're led to believe that if you don't like what's going on, just vote for somebody else. Like it's the electoral process that provides us our remedies, and only the electoral process. That's not true in a nation that is governed by the rule of law. Children, I would like to ask, I suppose, I don't want to put you on the spot, but you mentioned you teach the Declaration of Independence. One of the most significant the two provisions of the Declaration of Independence that I know are not being taught. There's a provision in the Declaration of Independence that states why people institute government. Why is that? What does it say? I'm asking. It's a key sentence early on. Why we institute our government. It's to secure our rights. People institute their governments to secure their rights. Period. That's the only purpose of our government, okay? And then I have the Declaration of Independence in this little book, right? It occupies 5 pages. 3 of those pages are devoted to a listing of the grievances that the early Americans, our founders, had against the government of their day. And so these 3 pages, it's he that is doing this, and they, the Parliament, he, the king, goes for 3 pages. At the very end of that list of grievances, you have what the constitutional scholars call the capstone grievance. It's the grievance that, more than all of the others, individually or put together, led to the decision to separate and to declare their independence. I'm asking, can you cite that capstone grievance, the grievance at the very end of the list? It's crucial that children understand this. What it says is we have petitioned for redress of these grievances, and our repeated petitions have been answered only with repeated injury. A prince or a government whose character is thus marked by every act which would define a tyrant is unfit to be the ruler of a free people. So in other words, they're saying, and we have petitioned for a remedy to these grievances, and our repeated petitions have been met with repeated injury, either ignored or worse. And yet, we have people who are petitioning today, who are petitioning their governing bodies, and they're being ignored. And, and that's the reason why those founders, a few years later, put that in the First Amendment. There are 5 rights guaranteed by the First Amendment in the order that they're mentioned. It's worship, speech, press, assembly, as we're doing here, and petition for redress of grievances. Crucial. And yet when people petition their government for redress of grievances, they're ignored or worse. Okay? These are important provisions, and they're not being taught. I would beg to differ with you. Yeah. I'm sure you had classes on the Constitution and the Declaration of Independence. But the law is the history, the meaning, the significance, and the effect of all the provisions in these documents. And they're not being taught. And so people, both in government and out of government, haven't been taught. And so we can't make the connection between what we're doing and what we're prohibited from doing without amending the basic documents.
Okay, Bob, thanks for your presentation. I'm asking that all your documents be provided to all the supervisors. We can discuss it further at a full board meeting and/or at a first future committee meeting, but we don't have a quorum here today. Thank you. Okay, next item is discussion on the boundary location is fixed by the state 1858, 59 Act to be continued at the next meeting with Real Property Tax Services Director and County Treasurer in attendance. So, we've got the County Treasurer, we got the Real Property Tax, and the County Attorney. So, how should we start? Martin, would you want?
Adapt the rules, Fred.
I
Excuse me?
might, you know,
Adapt the rules.
I might recommend,
Oh, yeah.
well, I might recommend in this instance, Mr. Chairman, that, Mr. Salvador go first and give a summary of what he talked about last time, and again, what he's looking for, and then give the opportunity for response by the treasurer and the real property director. That's my recommendation.
Okay, that's fine.
I'm sorry, I believe the point of departure is the agreements that we made at the last meeting that you were to pursue this and
I don't remember.
talk with Mr. Swan and Ms. Delury. I'm not prepared to say anything
Oh.
today, but to listen.
Oh, okay.
Okay. Okay, well, you made a presentation at the last meeting. I reviewed it. We did have a meeting. I told you we were gonna have an internal meeting to discuss it. We did that with the county attorney, with the treasurer, and the director of real property tax services. And I believe we have the assessor from town of Bolton, Mr. Rosebrook. So, I guess I would turn it over to,
If we could
treasurer.
hear from them first, then I might like to comment.
okay, that's fine.
Thank you.
Mike, you wanna comment? And Mike, I think everyone knows, was the former director of real property tax service also.
Basically, back in '07, I believe it was, John, you came to my office and we went over this as to the relationship with the boundary lines and the way they were drawn in Lake George, reflected between Queensbury and Bolton and Lake George. We went back, my office at that time, we did a substantial amount of review on this. I went to the archives in Albany. We hammered this out, and I feel that at that point in time, we put the town boundary lines on the tax map as accurately as we possibly could, based on the information that we had, which was that 1858 declaration by the state legislature. There have been a few minor amendments to that since, and we have done that. There's been a couple of court cases that set some of these boundary lines. Those have been implemented on the tax maps. And basically, from that point forward, we turn them over to the town. And in my opinion, the town then, it is their responsibility to use those tax maps or not use them, and the assessors to assess the property. Now, correct me if I'm wrong, John, here, but I think the gist of your question is, who has the responsibility for assessing the docks or not assessing the docks, and what they're attached to, and where they're located in the lake in regards to what town and navigable waters? Is that correct?
The fact that they're being assessed outside the boundaries of the town that's doing the assessment.
Okay, well, to that answer, that to me is pretty simple. That's a local deal, and I don't have one with me, if you look on the complaint on real property assessment form, and you go to the listing of how to grieve your assessment, there's under the C part, unlawful assessment, property has been assessed or entered on the assessment roll by oh, wait a minute, wrong one. Property is entirely outside the boundaries of the city, town, village, school district, or special district in which it is designated to be located. So this is basically your contention, and in my opinion, you would file one of these with the local town, and if the town declines your grievance, then your legal options become available to you to start litigation against the town.
I've tried that. There's a word in there that says entirely. The entire lot is not outside the boundaries of the town, only a portion.
Well, I mean, this is still, in my opinion, I mean, I've been doing this for a long time, this is a local issue. The county has no jurisdiction, no say, no clout, no authority to instruct the towns on how to interpret or do their assessments. That's strictly a town function. unless there were, I mean, there is one exemption to that, and that's under the state legislature if the county is an assessing unit. And Warren County is not an assessing unit. It is the local town that is the assessing unit. If there's a discrepancy in the town lines, that's something that, you know, Lexi and the mappers there they can work on again if there's more information that was missed when we did this back several years ago. But, you know, that's my feeling on it at the time, and it's still my feeling, that this is a local, the county has no jurisdiction over this, in my opinion. You know, I'll turn it over to the county attorney for his interpretation, but I'm not an attorney, so.
I believe that's the opinion I stated at our last meeting, and I continue to maintain that. I would point out for today's record that obviously Supervisor Stroh is not here from the town of Queensbury. I do know that he is continuing to search for a description, meets and bounds description of the town boundaries, and has, I think, contacted our state legislators and some others he had mentioned. I forget who, but he indicated he was doing some more research on it.
Right. But it's my understanding that you, Mike, and also our GIS department have agreed with Mr. Salvador's position that the 1858 and 59 statute is governing, and that's the way we've proceeded as far as Warren County is concerned.
Correct.
And I did discuss it with the county attorney, you know, and asked that we consider looking at that statute to see if it's ever been amended or repealed. And but it's a separate question on the assessment. Is your position, I think, right?
Yes.
Is there anything else you would add to that, Martin?
My office has begun the review of that to see if
okay.
there was any modification. So
Right.
far, we haven't been able to find any.
Right, but that would, if, whatever the result of that is, that would just affect what we do with respect to the tax maps and what we do with respect to GIS, what we have control over. But I think your position is we don't have control over the assessment function, which is at the town level.
Who assesses those docks is a local issue. That's a local issue between the town of Bolton and the town of Queensbury as to how that is done. It's just like any other assessment question. It's the local town and the local assessor who have the authority to do that. And that's spelled out, in my opinion, very clearly in the state law, in state real property tax law.
Okay,
And the county has no jurisdiction over it.
okay. Well, Gene,
Just a
Didn't really know that.
question. Let's just say that Mr. Salvador is right, that these towns don't have a right to assess those docks and stuff. Where do they go? Who assesses them then? Do they get lumped into the county portion of the lake, or do they get thrown into the air and disappear?
East and west, right, in this case.
Well,
The town of Bolton Landing has the water up to the shore in Queensbury, so then you're putting the docks into the town of Bolton Landing, but they're attached to the town of Queensbury real property. So that's.
There's always been kind of a gentleman's agreement that where that dock is attached is the town that it becomes assessed in. And this has been done not just in Warren County, but basically statewide. I, at one point, thought that there was an opinion of council on that, but I was unable to find it. But it's always been more of a gentleman's agreement than anything else. I mean, I was the assessor in Queensbury back in the 70s, and that's what we did at that time, too. Is that right? I don't know. That's something that the towns need to determine. But it's not a county question, it's a town's question.
like the county attorney's got some more.
yeah, I mean, let's, if you assume, Supervisor Merlino, that the town of Queensbury does not have the authority to assess those docks, okay, it would seem to me that either they are deemed unaccessible altogether, or the town of Bolton perhaps would seek the authority to create many, many, many little tiny parcels, to create taxable parcels for each of those docks, which would be not a fun task for Mr. Rosebrook, but I would assume, or his predecessor, or successor, as the case may be. Or, but I also, I believe I've heard Mr. Salvador raise a separate argument, that he is already being taxed on these by the Lake George Park Commission, and that he pays an annual fee for docks, as does everybody else. So that's another issue, and I think at some point in time, you know, there has to be some level of state involvement in this to figure it all out, would seem to me.
Mr. Weinschenk?
Yeah, all of this becomes a moot point in the ruling that Judge Krogman issued, saying that the towns do not have the right to tax state property. And most of these boathouses and that are on state property. This has been reaffirmed, they appealed the decision, and they lost. There's a 22-page decision affirming what Judge Krogman said.
I thought that, correct me if I'm wrong, Mr. Weincheck, but I thought that decision had to do with the provisions of the navigation law, and that there wasn't the authority of a town to, under its zoning powers, to regulate docks. But I don't believe it had anything to do with the assessable value of docks. I could be wrong about that, but I don't remember reading that. If I'm wrong, I apologize.
What happens is the county, towns, and whatever don't have the right to go on to state land and say, well, this is A, B, C, D, we're gonna tax it. That's the state's authority. This is a whole can of worms. Let's stick with Queensbury for a second. If Queensbury doesn't have the right to assess these docks, structures, whatever you wanna call them, then their assessed valuation is less than what they're claiming. Therefore, they're claiming more sales tax than they should be getting, and that's taking sales tax away from Mr. Molino and the towns and that are not on the lake on it. Now, that's wrong. Now, this also affects the school districts, because the assessment is used by the school districts to determine their fees. And if the assessment isn't there, the school districts don't have the right to tax that.
I'd like to hear from Mr. Rosebrook, because he's the one that has the unfortunate job of figuring out what to do on this.
Go ahead, John.
Can we do yours after, John?
That'd be
Okay. Okay, well, go ahead. I think this has been the rules.
Before we can adequately address the propriety of assessments, I think we've got to establish where are the boundaries.
Yeah.
That's the
Right.
first thing we've got to establish.
Right.
The boundaries that we are now using, there is no foundation in the law for those boundaries, absolutely none. And that's a declaration that has to come from the county board. It is that Real Property Tax Mapping Services, that's the only organization in the state that I know of that has the authority to map municipal boundaries and district boundaries. It's in the law.
John, the Real Property Tax Service has created tax maps that agree with your position, right?
Yes, but the town of Queensbury doesn't accept their,
Right, I
They're
understand that.
Okay,
Then
and
the further
that's-
question is, what jurisdiction do we have to?
yeah. Now, how do we
Force
get
them to
over
do
that hurdle? That's the first hurdle to get over.
Okay, thank you.
Thank you.
Mr. Rosebrook?
Sure, thank you.
Okay.
David Rosebrook, assessor for the town of Bolton, for almost 20 years. This has not been a new subject for me. It's been brought up over a number of the 20 years that I've been in service to the town of Bolton. Originally, when asked upon this question about assessment jurisdiction, we considered what was in place, and it was considered at that time, years ago, that the property rights for those docks and wharfs and boathouses, the property rights itself came from the dominant property on the shores of Queensbury, on the shores of Lake George in the town of Queensbury. So from that point, we always let the town of Queensbury do their assessing of properties that had the rights to these warehouses, wharfs, boathouses, and docks. Now, the boundary for the town of Bolton not only extends along the shoreline of the town of Queensbury, but also extends along the shoreline of the town of Fort Anne and also the town of Dresden. The same would all apply in that town. And to make matters even more, the town of Hague has a boundary line along the westerly shore of the county of Warren, in the towns of Dresden and Putnam. So the same issue would address even them. But here's the problem, and maybe our decision in the past was a matter of convenience. We never, being the assessor in the town of Bolton, I don't know who owns that shoreline in the town of Queensbury. I've never received the deed.
You don't have those records.
I don't have any of those records.
Right.
I have no, it's not on my tax maps. When a deed takes place on a waterfront property in the town of Queensbury, Fort Anne, or Dresden, I have no idea when it takes place, who owns it, and that those rights that proceed onto the state of New York property in the navigable waters of Lake George, it all happens unbeknownst to us. And so the wherewithal to gather that information and to be able to assess it is not in place at this time. It's something, actually, I'm thinking now that as a matter of law, it is in the town of Bolton. Those wharfs, now here's the other thing. We don't know whether that boundary line, other than it's stated that it's along the westerly shore of Washington County, along the Queensbury's westerly shores, to the point in the town of Lake George, and then back over to Bolton. We don't know whether that boundary is at the high water mark, mean high water mark, the mean low water mark, or someplace in between. Depending on how deep the water is right off the immediate shore, that could make some difference. So first off, I don't know what the distance is between the high water mark and the low water mark in some of these instances. In some instances, it's going to be next to nothing.
Yeah.
In some instances, it may be a dozen feet or more. I don't know.
Depends on the topography.
It all depends on the topography. But we do know that those improvements are real property. They can only be assessed by the local assessor. But the Krogman decision had nothing to do with taxation. It had only to do with what Martin said. I read the decision very carefully, so did our Bolton town attorney. It had only to do with rules and regulations applying to the navigable waters of the Lake George Basin. The town assessment office is not a regulatory agency. It does not apply. Only, in New York State, only the local assessor can tax property, with the exception of when a county becomes a taxing jurisdiction, or when the exception of the state assesses special franchise property. Those are the only exceptions in all of New York State. So, most likely, my conclusion is that what we've been doing in the past has been a matter of convenience. It's been a matter of we've never had the information available to us, from real property or any other agency, in order to gather those names to know what docks and what portions of them are in the town of Bolton or in the town of Hague.
But when you come to where something is assessed, I think Mike has pointed out that there's a well-established procedure. If someone believes they're being improperly assessed, in this case, I think he would file a grievance with the town of Queensbury, alleging that they're assessing it without authority, and then
Yes.
you can proceed through the courts with that.
Yep, right.
But we don't have any jurisdiction over that process.
No, you don't. That is the correct process, and that is the correct way to get, it may be the correct way to get to the bottom of all of this.
Right.
I'm saying, I really think that the boats, the docks and the wharfs, boathouses are all they are in the town of Bolton, they are in the town of Hague, up that way.
except unto this point, we've had no possible wherewithal in which to assess it. We have no way to identify it. It says clearly in the real property tax law, the local assessor is to identify and then assess all of the real property within his jurisdiction. As simple as that.
And the docks
Okay, thank you.
are not in your jurisdiction.
They're not in my jurisdiction? No, they are in my jurisdiction. But we can't identify them. We don't know how much of them are in my
But
jurisdiction.
that's not an impossible task.
It may not be, but there's gonna need an awful lot of administrative assistance to help us identify them and know what parts. But I truly believe that if a suit got started with just going the avenue that we're doing, out in an Article 7, a judge is gonna say, you were correct. They can't assess your dock in the town of Queensbury with your assessment because it belongs in the town of Bolton. And at that point, we better do some scrambling to get all of the real property that really lies in the jurisdiction of the town of Bolton, in the town of Bolton.
I am on my way to do that, okay, and the
Isn't there a riparian rights argument, though? Isn't there a riparian rights argument that goes with
It's riparian rights associated with
Oh, and incidentally, for Mr. Weinschenk, the local assessor assesses the state properties. The state doesn't assess their own property. We have almost $300 million of state islands assessed in the waters of Lake George.
And how is the authority for that come?
It comes as the local assessor is the only person that can assess
It's in the real property
in his
tax law, I
jurisdiction.
believe.
Real property tax.
The reason I bring that about is because, I guess it's never been questioned, because the towns and county don't have the right to go onto state property.
There's a court case on this, where the state used to do the assessments.
Right.
And give them to the local assessor, and the local assessor had to put them on. I don't remember the town, but somebody filed a suit against the state, and that practice was eliminated. And the town assessor has the right to assess state land. And they do it here in Thurman and Stony Creek,
Bolton,
Bolton,
Hague, all
I mean,
of
we have a
the towns.
tremendous amount of state
Lake George,
Okay.
all of them, Lake
Well,
Luzerne.
All I'm
We're
asking
really-
is, who's the authority? Who gave you the authority to do that?
New York
New York State
State
Legislature,
And that's in the law.
Yes.
it is.
We'll find it.
I think it's 432 of the real property tax law. But
I just have.
can we hear from Lexi and then
Sure.
John, we'll come back to you.
I don't
I
really
mean, I
have
think we are
anything
getting
to
a field when we get into the whole question of assessment because, you know,
we're not there yet.
okay. But, okay, just focusing on where the boundary line is, what our tax maps show, and what your position is directed at Real Property Tax Service.
Well, right now, our maps are in agreement with what John is stating.
Yeah.
And we're feeling that they're accurate. I think if there would need to be a change to do something with these docks, I really think that would have to go through the courts and have an opinion done that way, or a decision made that way, because we have no way of interpreting where all those docks are and what the descriptions would be for each one of those to create those. That would create numerous parcels throughout. And we have no way of gathering that information, and coming out with the description to plot out each one of those on our tax maps.
Well, actually, it could change by the seasons too, because if some of them are floating docks, you put them in the
Right,
spring and
and like
take
Dave
them out in
said,
the
you
fall.
know, we don't know where it is. Is it low water, is it high water? We don't know that.
Okay, John, thank you. Lexi. Yes, Mr. Salvador.
When we get to the issue of, and after we've settled where the town boundaries are, I have prepared here, and I have multiple copies that I can leave with you, a cross-section of a line along the shore, any typical one. And there are two statutorily established elevations on Lake George that we should accept and not try to change. One of them is the mean high water mark. That has been established by the DEC in Part 608. It has been established by the APA, and that is 320.2 feet above mean sea level. Fixed. Let's live with it. It's easy. And I maintain that because the water level of Lake George during the month of April usually reaches that high water level mark. It's usually that high. And the Park Commission has these records going back to the beginning of time, so we can check that. But as long as the water level rises to that level and the water is navigable, then that could very easily become our shoreline of Lake George. It doesn't go any further. If we call that the shoreline of Lake George, then the mean high water mark would become the boundary line between Bolton and Queensbury or the others. Very easy. Now, the way to establish that is to, in the spring, in April sometime, the Park Commission can ring the bell when the level gets up to 320.2. Everybody can go out on their front lawn and put pegs in the ground, and we know where the mean high water mark is. We haven't had to create it. We haven't had to change it. Likewise, the mean low water mark has been established back in 1963 by the revision to the Public Lands Law, Section 15A, and that's 317.74 feet above mean sea level. Again, established, it's there. And that range between the mean high and the mean low is private property. It's beyond the mean low that the state claims ownership of the land. I have a brochure here from the Office of General Services. And on navigable lakes, the demarcation between private and public land is the mean low water mark. So there is a tax parcel between the mean high and the mean low, and depending on the topography, it could be very long, it could be very short, but there's something there. And that's private property. The real property law states that the littoral owner takes title to the mean low water mark. Anyway, I'll leave this with you, and for maybe the next meeting I can do a plot.
I hate to do this, but can I ask you a question?
Yes.
Yeah.
So that means there could potentially be somebody could live on the east side of the lake, pay taxes to the town of Queensbury, pay taxes to the town of Bolton, and then the state would have to pay the town of Bolton taxes on the,
No, we pay taxes to the state in the form of a fee to the Lake George Park
Well,
Commission.
that
what
I,
about the dock though, that's what about the private dock that's on state land? Would the state be taxed for that portion of the
No,
dock?
we pay the state for that privilege. We pay the Lake George Park Commission an annual fee for, we register it and pay an annual fee for that
Just on
dock.
boats or just on docks?
Docks.
What happens if you build a boathouse out?
That's on the dock.
No, but what happens if it went out past the low water mark? Did that ever happen?
That's where we pay the fee.
Yeah.
That's the fee.
That's the fee.
And it's on boathouses and docks? Oh.
Yeah.
but,
I'm not fortunate enough to live on a lake, so.
Well, don't you see how we're being double taxed?
Yeah.
well, yeah, but that's if you concur that the fee is a tax, and that, my opinion is not, but more importantly, the county attorney's
Fee
opinion
is a tax.
is not.
That's in, but in any case, we get to that at a later date. The first issue is let's get the boundaries in the right place, and we can go from there.
Okay, I think we've got, the town of Bolton Supervisor, Ron Conover.
First, Dave, thank you very much for being here. Dave, as everyone knows, is certainly one of the finest assessors in the county, and we're certainly happy to have him involved. I'd Mike, you said something earlier, that, relative to, practice of the state of New York, across the state of New York, relative to waters, lakes, rivers, we certainly can't be the only, situation that has this type of issue across the entire length and breadth of the state of New York. Plus, our assessors belong to associations, statewide associations that make a professional, maintain a professional standard, a professional career relative to what they do and how they apply the standards that they apply, so that it's hopefully equitable and fair to everyone involved. So I guess what I was wondering, and Martin, while I'm not really interested in a jurisdictional question here in terms of getting answers, the county still has to produce a county tax rate for each of the municipalities, and it varies from municipality to municipality based upon full value assessment situations. So we do have a hand in creating a county tax rate, and then a county tax rate that's applied as a pro rata share to each and every individual town. Where I'm going with this is that it would seem to me that if we could ask Mr. Swan if he'd be so kind, or someone to, contact the state real property office and whoever else at state level, just to kind of track this down a little bit, because unless this is a homegrown invention of necessity that exists on Lake George, we should be able to, I'm sure these things have been challenged in the past elsewhere, and maybe we could track this down, because as Mr. Roseborough pointed out, we have no way, we have no mechanism for collecting that data elsewhere. We have no numbering system that applies to property outside of the town of Bolton, or likewise from Queensberry or Hague or whatever. And so maybe we could seek a little statewide guidance on this. Might be a good thing on the one issue. The boundary, I can understand if there's something relating to the map boundary that we have is continues to be in error. Well, we certainly should correct that.
Can I, just as far as that mapping, John, when the aerial photography is done for the tax mapping, it's done in April. And that's the basis, wherever that water level is, that's for the basis of where, when you draw the tax map, you run the property line to.
Okay.
So if you're saying that in April, it's at the actual high water mark, then we got it, we hit it.
Yeah.
Okay,
Mike,
well,
I
just-
jump ahead, but Mike, do you think that's something you could run aground with the state of New York?
Well,
I
Lexi,
can send it out to the,
Lexi's
directors
more
to serve and
established.
see how other,
Yeah, I think that would be a wise thing to do.
counties
with,
handle situations like
Because
this.
Dave's
There's lots of
experience
places
goes
across
back
New York.
with this, 20 years, Dave? But this practice goes back further than that. This is not, and it's not just, I don't want people to think it's just private docks. You have marinas, and you have commercial enterprises, and you
But this
have boathouses, and a variety of different structures that you're talking about here, and it's constantly changing. Some are coming down, some are going up. It's moving all the while.
well, since it seems to me that the only way you get to a binding decision here is by an act of the legislature, and I have discussed it with Assemblyman Stack, and there's apparently no appetite to pursue that, or legislation and a binding decision of a court. But do you have any other opinion on that? I just don't know how, we don't have jurisdiction to change it. We could say, or Lexi could say, okay, we've agree with your argument, and we're gonna change the tax map and create all these parcels with great difficulty, but still, that's not gonna be binding on the towns of
Don't have
Bolton.
to change anything.
Okay.
Don't have to. Let's get to the tax mapping and taxing, let's get that later. I can show you where you don't have to change a thing.
Okay, well,
Very simple.
I guess what I don't understand is what we do have jurisdiction over. I mean, you're making the appeal to the county. What can the county do that would solve the issue for you?
Enforce on Queensberry the fact that, there are known town boundaries that they're not recognizing.
I don't think we have the authority to do that, but
I don't either, and I think think that's a legal matter between Mr. Salvador and the town of Queensbury. If there's a lawsuit that's filed, we may be named as an indispensable or necessary party, but I don't know that we, by statute, have the authority to enforce Queensbury to do anything. I just don't.
They do not have the authority to map their town boundaries.
John,
This organization
John,
does.
I think the argument, I understand that, but I think the argument is that they're making an entry on the roll, or that they are assessing property they're making an entry on the roll for which their assessor does not have the authority to make, or they're assessing property which is not within their boundary.
Yes.
And or both of those. So, that's on the grievance form. Then then you file the Article 7, and you make your arguments before the court. And if you need to do that, you do it. You need to name the county as a necessary party, you do, well, you have to do that anyway under Article 7.
Okay.
You know, the other thing, Fred, is that, Dave, I mean, this could actually even bring in riparian rights,
Yeah,
relative, is that what it does?
There's no question about that. I mean, I would think that that would be an argument to be raised. I mean, you have, I think Mr. Salvador is right, where he states that where the property owner owns is to that mean low, I get that. But with any property comes a bundle of rights, and I think when you're a shorefront property, you do have some riparian rights. The state regulates that area, of the shoreline for purposes of docks, wharves, boathouses, etc. But, you may not be able to get a dock, wharf, or boathouse from the state, depending upon how much frontage you have or the particular conditions. But I think once you have that permit from the state, to build, I think that's part of your, I think that's part of your riparian right that goes along, the argument could be made, that's part of your riparian rights that goes along with your ownership of the dominant parcel.
Right, and it's not a big leap from there to also then make the connections with value.
Right.
So that, I guess what I'm saying is, we may have some overlapping, property issues here and water issues that make this, more complicated.
But the county has responsibility for the tax maps, but, and Mr. Salvador agrees that we've done the tax maps correctly, right? I say you agree that our tax maps are correct?
Yes, I do.
Okay. Jim?
Yeah, just a quick question, how much money are we talking about? I mean, the dock, how much is the dock worth?
A lot.
Variable.
Yeah.
I don't mean a boathouse, I realize that, but just the average.
Well,
The average crib dock could be as much as $55,000 to $60,000.
but Dave, excuse me, Mr. Chairman, is that just the cost, or is that the added value to the parcel?
That's just the cost of
Okay.
of the property.
Because I mean, I remember when I was counsel to Lake George Park Commission, and when someone came for a variance, they said, usually there was an analysis of what the property was worth with a dock and without a dock, and on the reasonable return argument, and some of those numbers were staggering.
Yeah.
You know,
The difference is,
The difference we
the
said-
added value to having a dock.
the added value to the parcel with a dock.
Gene?
I was just gonna make one last comment. I mean, I understand what's going on, but to me, as a small town supervisor that doesn't have lake values, Queensbury and some of the other towns, because their towns are being assessed at such high values, they're getting a larger part of our sales tax revenue that comes into our county, so the county is involved, because we're giving town sales tax revenues they might not get if their town value goes down a little. So that's I'd rather just see all these towns around Lake George, if they give up 1% of their sales tax, that sales tax revenue in a pool to go to some of the other towns, that'll solve most of the problems, nobody will complain.
But I think the opinion of our attorney is that we don't have jurisdiction to direct the town of Queensbury to relinquish those assessments on those parcels, or to direct the town of Bolton to assess them.
Well, they gotta do it on their own.
We have no
Nice
authority
guys.
over that.
Right.
But you sign the tax warrants at the end of the year, so the county does have. If the county is aware that Queensbury is falsifying their records, they should not sign that tax warrant. But getting back, just one other thing, my last thing for today. The town of Bolton has these properties, there's no question about it. I sat on the park commission and we discovered that back in the early eighties, we worked on that committee they had. So they're well aware of this. But the thing is, somewhere along the line, I don't know whether it was a gentleman's agreement or anybody just turned their back and said, well, you know, this is easier. You can't do that. State law is very specific. If the town of Bolton came along and said, look, Queensbury, you're gonna lose this land, suppose we give it to you. They can't do that. State law says they can only give up to $10,000, and that's with referendum by the voters. And I'm sure the voters of Bolton will go along, hey, let's give Queensbury more money. I think that would be a popular idea to get that vote out. So it's a blind no matter how you go, and regardless of whether you want to or not, somebody has to put their foot down and start straightening this out. And that's, I don't care whether Bolton gets the tax revenue, they don't get the tax revenue, but somewhere along the line it's gotta be made legal. And we've gotta say, okay, this land is not in Bolton, it's in Hague, or it's in Queensbury, or Lake George, or it isn't. Is it taxable, or isn't? Is it taxable on state land, or isn't? Let's get this all spelled out, so 10 years from now, we're not back having the same argument again.
But I just go back to what I said before, which is I think there's only two ways you're ever gonna get a binding decision on this. One is an act of the state legislature amending that 1858-59 law, or litigation. And so this committee doesn't have jurisdiction to do this, and the full board doesn't have jurisdiction to do that. I just don't know how you avoid, having it done either by the legislature, which hasn't shown any inclination to do it, or the courts.
We do have an interest though, Fred.
Yeah.
We do have an interest, if not jurisdictional, we do have an interest in helping to resolve or answer the question, as to the practice, And it is an issue that has kicked around for quite some time without what appears to be the definite answer. And I think that if we could get something in writing from the state of New York, or if there's some case study out there that we're unaware of here, sitting here today, that might provide the kind of information that would be extremely helpful to the discussion.
But it's not going to give us anything on that boundary line, I don't believe. I don't see how it could.
No, but I'm not sure at this stage that we have much dispute, on the issue of the boundary line. The town of Queensbury I know last meeting, the supervisor of Queensbury had some maps and was, talking about meets and bounds and whatever, but for taxing purposes, at least stay focused on that, for taxing purposes, all property, real estate property in the town of Bolton is being taxed by the town of Bolton, and all real estate property in the town of Queensbury is being taxed by the town of Queensbury, so that's not the issue. So, but I think getting, if it exists, if it doesn't exist, that's also a conclusion as well, that we can't answer this definitively, and the practice has been the following, and you're absolutely right, until such time as that's challenged, that's I guess how it has to lie, but.
Okay, I had another question back there.
One of the things that I haven't heard in any of this discussion is exactly when this festering problem started. How did it occur? And is that known?
Excuse me?
Needs to identify himself.
Oh,
When
could you
when did these boundary issues come begin?
1858.
What?
1858.
1850.
Yeah. Sir, could you identify?
But it's pretty clear in 1858 what it said. So it was crystal clear.
Government works slow.
I guess so.
Could you identify yourself for the
Frank
minutes?
Cicero. I'm a member,
Oh, okay.
I live in the town of Bolton.
Okay, thank you. Well, I think we spent a lot of time on this. Unfortunately, we don't even have a quorum. And I don't see how we're gonna resolve anything today, but.
I am on my way to an Article 7 in the town of Queensbury on that very issue, that my boathouse is in the town of Bolton. What if I lose?
Mm-hmm.
What if I take it to court and lose?
just one
Well,
other quickie. When I was on that commission for the, Park Commission, we worked with two state attorneys, and they researched this back to the 1858. They cannot find anywhere in the legislature that this was ever changed. Or that there was ever a gentleman's agreement saying Queensborough, you can tax this. That, they had no record of it. They couldn't find it anywhere.
Well, I think the opinion of the attorney, and it's also my opinion, is that it's gotta be resolved through the courts. So I think you're going in the right direction through. I don't know what else we can do.
And you won't mind if I join the county?
No?
Well, in an Article 7,
I think you have to.
You have to give us notice, and we can, we can,
Make it a combined.
well, we can appear or not appear, as the case may be. But think of it this way, John, if within the context of the lawsuit, if you're seeking relief, which is somehow going to impact the county, I think you have to name us.
Pardon me?
I think you have to name us.
I could make it a combined at Article 7, Article 78.
That's been done before, that's correct. That's been done before.
Because in that way, that would get to the issue of the allocation of the sales tax, which seems to be a concern also.
No,
No, I think that
If
gets...
the assessment changes, the allocation of the sales tax changes.
Well, maybe it gives Mr. Salvador multiple, different options to pursue the relief against Queensberry that he's looking for.
No, I would keep it as narrow as possible.
Okay, well,
Any outlaw, narrow.
Now, these other towns, they could file against Queensborough, you're taking my money, which is
Yes,
another.
Jim, then I think we need to wrap this up.
I was talking to Rob this morning, and he said Bolton's taxes are gonna go way, way up. So you might wanna change your course.
We'll take care of that.
Okay, well, we've had a very long discussion, so thank you, John, for coming in and discussing it with us, and thank everyone else that appeared. The only other item we have is a referral from the Health Services Committee requesting a letter of support for legislation mandating elder abuse reporting. I think that's something that Rachel brought up, but are you prepared to, she's not here.
I'm not.
No.
I don't know anything about that one.
I suggest we just table that and adjourn the meeting of a meeting that we have without a quorum. Okay, thanks, Bob and John. Longest.